Hello and welcome to this CIArb adjudication webinar, Beyond Construction. How can adjudication be used more widely? My name is Lewis Johnston. I'm Assistant Director for Policy and External Affairs at the Chartered Institute of Arbitrators. And this is the third in a series of adjudication thought leadership discussions that we've been hosting over the summer. The first two dealt with, in turn, 25 years since the introduction of statutory adjudication in the UK through the 1996 Housing Grants Act. The second discussion focused on how adjudication can be more amenable to lower value disputes. And this third discussion today is looking at whether adjudication as a mechanism would have some utility beyond the construction sector for which it was first introduced. I'm delighted to be joined by such a distinguished panel here today. We're joined by Sian Mirchandani. Sian has wide and considerable experience of professional liability claims, including claims against lawyers, architects, engineers, and a range of other different professions. She has experience as a Tech Bar accredited adjudicator, and has recently qualified as a fellow of the Chartered Institute of Arbitrators. Sian is building a practice as an arbitrator, and she sits as an adjudicator on the Professional Negligence Bar Association's adjudication scheme. We also are joined by Ken Salmon. Ken is a solicitor qualified in England and Wales and the Republic of Ireland. He is CIArb qualified and CMC accredited as a mediator. He is chair of the Education Committee of CIArb's Northwest branch, and is the author of cases on the enforcement of adjudication awards from 2012. He's also a construction specialist working as a consultant to Slater Heelis, and has extensive experience of discussing this subject about the application of adjudication outside of construction. So welcome, Ken. Next, we have Marcus Cato. Marcus is Honorary Secretary of the South East branch of the Chartered Institute of Arbitrators and co-chair of the CIArb Board of Management. He has over 25 years of experience in international construction and engineering disputes resolution, particularly in East Africa and South Africa and the UK, and has over 20 years experience in working as both party representative and managing adjudication disputes for large and small clients in all aspects of construction. So welcome to our distinguished panel. I'm delighted that I'm joined by you all here today to discuss these issues. We're going to start with a discussion in general about why adjudication is of value and what it has sought to achieve and what it has achieved for construction, before going into examine some of the examples of where adjudication has already been applied outside of construction. We will look at what has worked for that, perhaps what hasn't, what has driven take-up and what the barriers to take-up may have been. And then we'll go into a bit more detail on where the other opportunities may lie, or which other sectors may be particularly amenable to or would benefit from adjudication as a means of redress. We are able to welcome here today an audience from all many different regions. I'm really pleased that you've given up your time to listen here today, and I hope you find the discussion informative and hopefully really quite interesting. You will be able to submit questions through the Q&A function at the bottom of your screen. If you're having any issues, you can let us know through the chat function as well. We will set aside some time in about an hour's time towards the end of the session to focus entirely on audience Q&A. But if there are any questions in the meantime, please do feel free to submit throughout the session, and we will I'll pick those up and incorporate them into the discussion. We do find with these sessions that they work very well as interactive dialogues between ourselves on the panel and the audience. So please do get involved. So to start with, I wanted to talk more generally around what the benefits of adjudication are. And I'm very delighted that one of our panelists is going to give us a brief overview on what adjudication is intended to achieve and how it's done that for construction. And then that will lead into the discussion of why that might have utility in other sectors as well. So firstly, over to you, Ken. Can you tell us what the main features and benefits of adjudication are, and why they've worked so well for construction, particularly since 1996 in the UK, but also perhaps touch on the international dimension?
Thank you, Lewis, for that introduction. Good morning to everyone, or good afternoon, or good evening, depending on where you're joining from. Thank you very much indeed for joining this, what I hope is going to be a very informative discussion. Some of you will be familiar with the background to construction adjudication, others may not, and those who are will perhaps forgive me if I just start by very briefly outlining the history of construction adjudication as it has been adopted in the United Kingdom. So in England and Wales, in Scotland and Northern Ireland, adjudication was introduced by the Housing Grants, Construction and Regeneration Act of 1996 and came into force in 1998. And that act meant two things to the construction industry. First, that there was going to be a mechanism in all contracts, construction contracts, to ensure that payments were made properly, that people were properly notified of what they were entitled to, that payment was made by a certain date, and if not, and absent a notice that there was no entitlement, then payment had to be made by a final date for payment. Because arbitration and litigation are fairly blunt instruments and can take quite a long time, it was necessary to back this entitlement to payment by some quicker mechanism, and adjudication was introduced. So the second part of the Act, which dealt with construction, provided that the parties had a right to adjudicate at any time, and that adjudication would effectively take place relatively quickly, and I'll come to that in a moment. The Act was amended in 2009, coming into force 2011, and so far as adjudication is concerned, the only amendment that we need concern ourselves with was that adjudication was extended from written contracts to all contracts. Just one little word. Construction contracts are defined in the Act. They actually encompass virtually all construction contracts: building, civil engineering, demolition. They extend to design obligations. So virtually everyone concerned who enters into whether a main contract, subcontract, professional appointment may be subject to adjudication, except certain industries which were felt to regulate themselves very well, such as rail, pharmaceuticals, oil and gas, and food production, which were not subject to this statutory regime. The point about all this is that it has statutory backing, and it was effectively compulsory. You couldn't contract out of the right to adjudication, and you couldn't be prevented from adjudicating once a dispute had arisen. So that's the background. So Mary, if you could put up my first slide, please. We'll look at the main features of adjudication as it's been used in construction. So the nature of the process, well, it's adversarial, but with an inquisitorial dimension, in that the adjudicator is entitled to ascertain the law and the facts for him or herself. It's proved to be mainly a paper process, and that was what was intended. But there may be occasions when adjudicators will visit site or hold meetings by telephone, video conference, or indeed in person, prior to COVID at any rate. so that a particular topic might be discussed. And the adjudicator sets the procedure. The main feature of adjudication is that it produces a binding decision which the parties are contractually and statutorily obliged to comply with for the time being, unless and until the dispute, the underlying dispute, is finally resolved, whether that's by litigation, arbitration, if that's what the contract provides for, or by agreement. That is the key thing about adjudication. It produces something which is binding, but only for the time being. It decides where the money lies, effectively. And it's summarily enforceable. So this adjudicator's decision will be enforced by the courts. Could I please have slide 2, Mary? Right, so what are the benefits of adjudication? As widely perceived, other people will have, some people have slightly differing views as to whether everything is a benefit, but speed. Essentially, the statutory process is to take place within 28 days. That time can be extended by 14 days in the gift of the referring party, and it can be extended beyond that if both parties agree. Often the adjudicator will decide whether they need more than the 28 days and will ask the parties to agree to extend his or her time. And it would be a brave party who said no. So typically for, let's say, the ordinary small to medium-sized or fairly straightforward dispute, the timescale for adjudication will be 6 to 8 weeks. For larger disputes, and there have been very large disputes which have gone to adjudication, and sometimes very sophisticated disputes, not always about money, it can take longer. It can be several months. But if you think about it, how much quicker is that than litigation or arbitration, which could take a year or 2 years? The statutory regime provides that the parties will each bear their own costs. So there is no liability for your opponent's costs if you adjudicate, which was, I think, supposedly an incentive, and generally, I would say, is an advantage rather than a disadvantage, albeit that there have been adjudications where the parties have spent £100,000 on their own costs. And that's an add-on, if you think about it, if it's only temporarily binding, because eventually, if it goes to litigation or arbitration, those costs are not recoverable and they're added effectively to whatever the litigation or arbitration will cost. The adjudicator's fees are paid as the adjudicator directs. It's still, however, in my view, and generally accepted to be far, far cheaper than arbitration or litigation. So that's another benefit, i.e. speed and cost. Could I have the next slide, please, Mary? The adjudicator will be an industry specialist, often chosen by the parties, can be named in the contract, but otherwise will be someone from one of the adjudicator nominating bodies, panels in effect. And those were quickly set up and have been developed, and the adjudicators who qualify for panels are properly trained, properly qualified, and assessed periodically. And effectively, you're going to get a true specialist in whatever field you need. I've said it's a temporary fix. Well, it hasn't been limited to chasing money. It will decide where the money sits pending a final determination, but it can decide other rights and has been widely used for things like determination. Was a determination lawful? Has the contract been repudiated? And such things as that. So determining parties' rights or what the terms of the contract are or mean. It's enforceable by expedited summary judgment. The courts quickly supported the whole process. Summary judgment was the right way to go. That was decided very early on. And the process was streamlined to ensure that parties weren't kept out of their money. So there were things like time limits being abridged so that the acknowledgement of service of the proceedings was to be filed within a shorter period as 4 days instead of 14 days. Any defence, likewise, within a short period, evidence and so on, and then a hearing quickly arranged. And the whole process began with a view to the summary judgment application being made. To back up the statutory regime, the judges also very quickly decided, in Sir Peter Coulson's words, that adjudication meant pay now, argue later. So basically, the adjudicator's decision would be enforced, provided it was within his or her jurisdiction and provided the rules of natural justice were observed and the decision was given in accordance with the process. Subject to that, the decision would be enforced right or wrong. And to back that, there would be very limited grounds to resist stay execution, because that might have been a backdoor to deprive someone of the benefit of the adjudicator's award. And there's a case called Wimbledon and Vargo, which decided the principles on which a stay might be granted, and they're very limited indeed. Perhaps I could have the next slide. Please, Mary. Right, thank you. I should mention, because you might now be thinking, well, this sounds like some form of expert determination. And indeed, it has great similarities with expert determination, but with crucial differences. I'm suggesting that the rules of adjudication, effectively, not just because they're set out in the scheme for construction contracts, and indeed contractually in many cases, or you can adopt institutional rules, such as those of the Technology and Construction Solicitors Association, TEXA, or the ICE, and so on. But also, these rules have been subjected to judicial scrutiny over quite a long period of time, 22 years. And I think everyone pretty much knows what they now mean. Compare that perhaps with the typical expert determination clause, which might be relatively short and not always well defined, leaving the procedure and the process in the hands of the expert, and the parties won't know until the expert's appointed and sets out directions what they're in for. That really goes on to the second point, which is the greater clarity of the role and the powers of the adjudicator over the time, over the period for which we have case law. It tends to be quicker and cheaper than expert determination. I know one can have a very short expert determination, but typically a period for the expert to determine matters is 20, 30 days, and often longer. So there may not be a great deal of saving in terms of time, but there may be some. Expert determination is intended usually to be final as well as binding, subject to manifest injustice, whatever that means, and there's uncertainty in that. So I would suggest that even if it's seen as a form of expert determination, it is preferable to the normal form of expert determination, and we'll consider later how suitable it might be in other spheres than construction. I think that's really all I need to say by way of introduction. Thank you very much indeed.
Thank you very much, Ken. That was a really, really informative and quick fire presentation. You packed a lot into a short period of time. So I think that gives us a really strong basis for the discussion. Marcus and Sean, was there anything that you wanted to add before we go into perhaps a bit more detail on how transferable some of those principles might be to other sectors other than construction. Did you want to add anything to Ken's points around the utility and benefits of adjudication?
Well, I think this is something that I will also be covering when I start to do my presentation. But yes, the obvious attraction of adjudication is that it has provided an alternative route which has remained largely quicker and cheaper than the other ADR routes. Arbitration perhaps began that way and is heading rather more in the direction of the way litigation is going, which is costly and lengthy. But hopefully adjudication will remain as a more speedy route for dispute resolution. And certainly there is scope for it to be broadened.
Thank you, Sean. And Marcus?
The benefits I see of adjudication is applicability across different jurisdictions and more internationally. I think a common approach is really beneficial, particularly where contracts span over different jurisdictions or supply chains. So there are real benefits, I think, internationally, providing you can get the statutory right to adjudicate and enforceability right.
Thanks, Marcus. I think that statutory underpinning is a question that we're hopefully going to discuss in some detail later on. So thank you for raising that at the moment. Thanks also to the audience for sending through your questions. We will definitely come to as many of these as we can later in the session. I did see just one thing that's relevant for the next stage of the discussion. Ben Beaumont was talking about adjudication being considered by Untitled for its future work, and also about the fact that his NGO has drafted a model law for adjudication, and that bodies such as the ICC are looking for actively at mechanisms to improve cash flow to small suppliers, and whether an interim binding mechanism like adjudication could fulfill that is a very interesting question. I think now is a good time to move on to how adjudicative processes may have applied elsewhere, and then we can get into what some of the barriers to take up may have been, if indeed there have been barriers. Sean, I said in the introduction that you're an adjudicator on the Professional Negligence Bar Association's adjudication panel. So I wondered if you could talk us through the experience of that scheme since it was established, and what you think it might tell us about the broader applicability of adjudication.
Certainly, thank you, Lewis, and good day and greetings to everyone in this truly international audience of fellow professionals who are all aware of these different means of dispute resolution. I'm a barrister at 4 New Square Chambers in London, and I've worked within the fields of both construction and professional negligence for around 24 years. During that time, the adjudication scheme in construction was introduced under the 1996 Act, as Ken has perfectly and succinctly described. Whilst that has applied for construction, outside the field of construction professionals, there hasn't been an equivalent, and disputes have largely continued to pass via the stages of the High Court process. And that has brought with it various problems, largely to do with costs and delay. Now, within the UK, that High Court process has changed significantly during that period, with the introduction of a whole new procedural table of rules called the CPR, or Civil Procedural Rules. There have been things called pre-action protocols, things called cost budgets, whereby each party sets out how much they expect to spend, and a judge decides whether that's a proportionate amount and rules on that. The introduction of a £10,000 issue fee before you can start your proceedings in the High Court. And now we have an additional layer of control, which is the disclosure pilot. Now, all of these measures are designed to make litigation route more effective and more cost effective. Unfortunately, they all involve a front loading of costs. Now, that makes litigation a less attractive route for somebody who wants speed and wants to know how much they're going to be in for in terms of costs. Now, as I say, for most of that time, there's been no equivalent for cost-effective, quick ADR other than mediation. And the position in the UK changed in February 2015 when a pilot scheme for adjudication in professional negligence was launched by the presiding judge of the TCC, as he then was, Mr. Justice Ramsey. That pilot has since evolved, and the Professional Negligence Bar Association, which is a professional specialist bar association in the UK, introduced what's called the Pnba adjudication scheme. It began in May 2016 and it was relaunched in February 2019. It has the backing of the judges, and two judges, Mr. Justice Fraser and Lady Justice Mrs. Justice Carr, she then was, now Lady Justice Carr, were very much involved in the working party and supporting the scheme. In this brief outline, what I'm proposing to do is mention two decisions which have come out of the UK court. And one of those is a recent one, and one of those is an older one, which demonstrates the current view and perhaps the older view of adjudication in professional negligence complaints. And then I'm going to have a quick canter through the rules and guidance of the Pnba adjudication scheme, all of which is available via the Pnba website. Right, that deals with slide 1. Could I go on, please, to slide 2? This is the recent case, which was decided by Mr. Justice Fraser, who was, as I said, one of the people supporting and involved in the working party for the scheme for Professional Negligence Bar Association adjudication. The facts of this case I'll quickly give you. It was a claim involving a claimant contractor and one of its major shareholders for a breach of contract and professional negligence brought against the engineer that had designed the foundations at a construction site where there were 2 residential blocks. The claim was for a sum of £3.7 million. What had happened prior to the actual proceedings was that the contractor had already taken the decision to demolish the buildings because he was asserting that this was due to the negligent design of the foundations. The outcome of the case, in short, was that the judge held the engineer had negligently designed the foundations, and which also had other numerous defects, but the case failed entirely on causation because the contractor had not given its groundworks subcontractors the most recent designs from the engineer, and because there were serious designs in the construction of the blocks themselves. The outcome of this claim, which ran in the High Court, is an award of just £2,000 to the claimants, which reflected a small cost that they had incurred on partially completing some remedial works prior to undertaking the demolition. Fraser J. noted that the claim by the contractor was weak and speculative. As for the claim by the shareholder, there was no contractual link and there was no basis for asserting a standalone duty of care between the engineer and that shareholder, so the claim failed entirely. Now, with regards to the entire litigation, this is what the judge said. He pointed out that there was this Pnba adjudication scheme. He indicated that if it had been used in this case, what would have happened? An experienced Queen's Counsel, it can also be a senior junior, but either way, it's somebody who's very experienced at dealing with professional negligence claims, would consider the claim and issue a non-binding decision. It is a scheme that is supported by the insurance industry, amongst others. And he indicated it was a great pity that the parties had not adopted that method of resolving their dispute, which would have been far, far quicker. This was a trial that lasted for over 3 TCC weeks, which are 4-day weeks, with all the costs that would have involved. In essence, the case really concerned that issue of factual causation. There were 6 experts called for this claim. The negligence had even been admitted in certain respects. There was nothing unusual about the case, and it all turned on a causation, proving causation. And he pointed out that adjudications can, in suitable cases, also proceed with oral evidence and cross-examination of witnesses. He concludes by saying it would have been a far better way for the parties to have proceeded. I've mentioned about the use of an experienced Queen's Counsel. Queen's Counsel is the equivalent in the UK of senior counsel, for example, in Australia and India. And it is, in essence, somebody who has been decided to have reached the required standard of excellence in their fields, which is a letters patent position that they gain from an independent body that determines it. Secondly, the scheme is supported by the insurance industry. The source for that comment appears to be that the Association of British Insurers, which is effectively the global entity for insurers in the United Kingdom, were on the working party for the scheme. And during that course, it was very much the case that the parties involved were looking at how successful construction adjudication had been. And thirdly, the route to getting to these faster, cheaper decisions via adjudication was to have an adjudication clause present in the contract. The scheme stipulates that it will be a 56 days turnaround from the date of appointment to the date of decision. Could I have the next slide, please? Now, this is a case from the past, which is where adjudication in the form of construction adjudication was dealt with nearly 20 years ago by the TCC, a different judge, of course, but by the same court, when it was considering whether or not a professional retainer of an architect by a residential property owner was a retainer that had incorporated an adjudication clause. Now, the adjudication clause derived from the RIBA, so the Royal Institute of, I'm so sorry, I can't remember what the BA is now. It's the architectural professional body. They had their own standard conditions of engagement, which incorporated an adjudication clause. And the architect in this case sought a declaration that his written contract with that residential property owner was both enforceable and incorporated those conditions, and that therefore there was an adjudication provision. He had pursued adjudication because the question was whether the award in the adjudication was enforceable. He failed to achieve that. The judge held that the architect hadn't followed the appropriate guidance from the body that had created this adjudication clause, and that required him to have drawn the attention to the onerous nature of the adjudication clause to the client. And the reason that it went this way is that that clause was detrimentally balanced against a consumer's interest, and the consumer in this country is protected by statutory rules such as the unfair terms in Consumer Contract Regulations 1999. So even if the provisions had been incorporated, they would have been found to have been of no effect. So the adjudication provision was effectively struck down. Now that's a very old decision. It's closely tied to its facts. It involves a residential property owner, which would not be permitted to be involved in construction adjudication now in any event. There's clearly a change of heart in the courts. And even on this case, if things have been done factually differently and the adjudication clause had been drawn to the client's attention before the engagement proceeded and ended up in dispute, then it may well have had an entirely different outcome. Could I have the next slide, please? Now, there's an extensive 21 sections of guidance for the scheme. I'm not going to do anything more than touch on a few matters of that. Section 3 looks at the types of dispute that are suitable. Interestingly, the dispute is considered to be suitable for a case where there is a number of disputes between the parties, or where there are issues or matters in a much larger dispute. So you can involve one defendant and respondents or you can have related disputes between a number of parties that can be referred to adjudication together. Section 7, that's where the rules set out the quick turnaround. So within 5 days, the appointing body will nominate an adjudicator and communicate that to the parties. And then, as I say, within Section 10, the steps to be taken, the adjudicator will write to the parties, confirm the appointment, and set out the directions to enable the case to be to the point where within 56 days, the written decision is returned. And what is the position on costs? Well, in essence, the parties have a choice. They can either allow the adjudicator to direct one party pays all or part of the fees and the fees of the other party, or they can direct and agree otherwise that the adjudicator does or does not have a wider discretion on costs. All of the fees that are payable within this cost provision are payable within 21 days of the cost determination. Could I have the next slide, please? I'm just going to quickly summarize a few questions here. What is the purpose of the scheme? It's a quick and new cost-effective means of ADR, which has drawn from the construction adjudication scheme and is going to be intended to be applied to other professionals' disputes. So the other professionals would include lawyers, accountants, architects and engineers would probably end up being dealt with within the construction adjudication scheme, but they could, of course, become disputes within this scheme. The scheme is now in the pre-action protocols, which, as I mentioned, were in addition to the rules of the High Court, so that the parties are required to consider it, but it is not a compulsory matter that they have to look at adjudication. What are the essential elements of the scheme? Well, firstly, the parties must agree to be bound. It's a voluntary scheme, but once you start it, you have to stick with it. Secondly, the parties can either select their own adjudicator or ask the chair of the Professional Negligence Bar Association to do the selection. The adjudicator will ask for evidence from written submissions from the parties. They may seek a short hearing. They may wish to hear oral evidence. The decision will be returned within 56 days, and it will be binding unless challenged by a court or an arbitral tribunal. So very much similar to construction adjudications, but different to another form of ADR, something that was called early neutral evaluation, where you would get a judge or similar to look at the case and come up with an indicative decision, but that was not binding. Sixth, both parties may be liable for the fees. Seventh, confidentiality. The submissions and evidence exchanged in the process will be confidential, but unless otherwise agreed, the decision will not be confidential. Finally, the rules do allow for there to be multi-party adjudication. So what sort of disputes might be appropriate for the scheme? Well, all professionals, it was hoped, would be involved in this scheme. And the reason for it being particularly suitable to professional negligence is that, of course, a great deal of the matters in dispute will turn on the documents. And a lot of the liability decisions can be reached without the input of experts. In fact, in the United Kingdom, it is very seldom that you would be able to get permission to have a legal expert witness give evidence. A suitable case is one where somebody who is in a senior position could resolve the issues, usually on the papers. It's particularly suited to cases of modest financial value, which perhaps have complex legal matters that can be resolved on the paper without a great deal of evidence. What are the disputes that are not suitable? Well, anything requiring complex expert evidence is probably not going to be suitable for this scheme. It's unlikely to be suitable for clinical negligence cases for that very reason. Cases which require expert witness, well, this is not an absolute cutoff, but if an issue is to be determined on breach of duty and involves witness evidence, particularly where there may be allegations of dishonesty, or lack of frankness and deceit, then it's probably not the suitable route. And another point is cases where a losing party is likely to, after the event, consider that they hadn't had a fair platform. Quite how one selects that sort of case at the start is difficult to say, but it's looking at cases that have intractable qualities, such as, for example, if mediation has already failed, then the chances are going via adjudication is not likely to be your route. Can we move on to the next slide quickly? Thank you. So how is the scheme engaged? The parties, once they agree to do this, will have to write to indicate to the chairman of the Pnba to indicate they wish to have an adjudicator appointed. They outline the dispute that's being referred and point out that the parties are agreeing to be bound by the rules. Parties must bear in mind that the rules provide a number of alternative options, and so it is necessary for the parties to be able to reach agreement on each of those stages. Who will be nominated and how? Well, that is somebody independent of the parties with no interest in the dispute. The adjudicator will consider the nature of the dispute and the time limits, but by accepting the appointment, they will be confirming that they are competent to provide a decision in that dispute. What are the costs involved? Well, there is a sort of built-in category of low value, low costs, so that it is kept as being suitable for smaller cases and cases of small value. There is a ceiling of cases where the ceiling is £10,000, but the legal costs are nonetheless likely to be significant, and it's considered as a proportion of the value of the claim. There remains a category C, but there is no ceiling, and that will be for the rather more complex dispute. How does it proceed? Well, just like in construction adjudication, after the adjudicator is selected by the chair, they will sign the terms and conditions. The adjudicator will contact the parties to confirm the appointment, give their details of hourly rate and terms and so on, and give directions or fix a telephone conference so that directions can be given, and thereafter will set a timetable. The adjudicator will normally have broad powers, and they can therefore determine the jurisdiction that they have within what is within the dispute and what is not. What is the status of the decision? Well, it's binding. So the parties agree that it will be binding, and therefore it is a final determination unless one party decides to dispute it by taking it into some other form of dispute resolution, such as court or tribunal proceedings. If the losing party doesn't pay within 21 days, the successful party can seek enforcement in the court. There is no route of appeal to a higher level in adjudication, but of course, it's only binding until determined by that second level of determination by the court or an arbitral tribunal. However, the parties can write in that it will be binding and final within their agreed terms if they wish to do that. And they can write in that the decision will also be confidential. The default position is that confidentiality covers everything bar the decision. The adjudicator, of course, will be subject to the usual requirements for confidentiality. Now, looking at the future, this may well trespass into some other issues that we're going to speak about later, and I'm wondering if I have enough time to deal with them now. Lewis, I'm in your hands. I'm conscious I've run on.
No, that's fine. Thank you, Sean. Please go ahead.
Okay, well, there have been serious issues with uptake. There have only been 5 Pnba adjudications in the last 2 years. And looking at reasons for why that has happened, there don't seem to be any standard forms using adjudication as a dispute resolution clause. The only ones that I've been able to locate refer to adjudication, that's the RABA standard terms, has a provision for adjudication, and so do the Association of Consultant Architects, but they are both construction adjudication. They don't specifically refer to the Pnba. The other instance is Insurers support for this. Now, within PI insurance, there is a commonplace ADR clause, which is called the QC clause. And that is in effect a provision that is similar to an adjudication clause, but it has in fact been held in a UK court case dating from 2001 to amount to an agreement to arbitrate. So the QC clause is not going to be sufficient to enable parties to say, well, actually, this is an agreement to adjudicate. It seems to me that it is likely that there will need to be an adjustment of those insurance terms or a change to the retainer terms that these professions engage upon before there is going to be the same boom of cases that there was in construction adjudication following the introduction of the Act. This scheme of adjudication does not have a statutory power behind it, which is clearly making a big difference to the level of uptake.
Excellent. Thank you, Sean. I think that's really, really useful, particularly as essentially a case study or a worked example as we go into some of these questions around what makes adjudication effective and what are the necessary conditions in order to boost uptake. Particularly, I think around this question around the statutory underpinning. Obviously, you mentioned there that the Pnba adjudication scheme is included in the pre-action protocols, and that obviously indicates quite a level of support, but without that statutory grounding, I think that's an interesting question for the panel to explore. Before we come to those questions, I wondered, Marcus, if you wanted to just follow some of Sean's comments there and just start off the discussion around what some of the other sectors are that might be amenable to or would benefit most from an adjudicative process.
Okay, so I suppose I come from a different sort of approach, really, in terms of saying where would adjudication be applicable. I think the drive, to a certain extent, I think Sean has highlighted it. The drive comes from each individual sector. We talked about uptake, and therefore the core principles of adjudication, if suitable for a particular sector or industry, the need for that should be driven from within based on the experience of those individuals in that industry, in that sector, because this effectively, to broaden adjudication, it has to come from within, driven by a need for change. So for me, it's about adjudication is applicable to any application in terms of dispute resolution, providing that there are some key benefits to it. Some of the viewers may or attendees may have experience of adjudication and have good experiences and bad experiences, but adjudication in terms of its principles is based on time limiting the process with the benefits of early decision making and sometimes, hopefully, more often than not, benefits in cost reduction. So achieving an interim discussion, as Kenneth has said, in terms of determination for payments to keep cash flow moving is really important. And those people who are attending from international jurisdictions, I'll probably roll onto that a little bit later. The issue of having a statutory right to adjudicate, I think, is any benefit really is really important in the different jurisdictions. So anywhere where the enforceability and a right to adjudication can be formed is beneficial in terms of the application of adjudication. I think what we have to look out for, and when people want to select adjudication or promote adjudication within their own industry sector, is that there are some downsides. Getting the right adjudicator can be an issue in terms of expert knowledge, familiarization with the processes and procedures that Sian has pointed out, and the applicability of making sure that all the legal boxes are ticked. So having a good adjudicator is key. The propensity for weaponization, Ben mentioned it in a question on the chat about fees and party fees, making sure that adjudication remains balanced, not using it as an undue commercial duress, if you like, between an imbalance between parties. So if you can overcome those, it's applicable, I believe, in all areas of dispute resolution. And primarily, Kenneth mentioned it, where there is expert determination, primarily used in my experience in IChemE successfully, you have the ability to time limit expert adjudication. And as Kenneth has quite rightly said, expert adjudication tends to be a little bit more expensive, a little bit more drawn out. So adjudication applied to any scenario where expert determination is used is beneficial, because you have the time and you have the cost benefits of limiting that time. Lewis, I know you've done quite a bit on technology, and perhaps it might be worth you just coming in on the back end of this, just sharing your discussions recently with some of the technology bodies in terms of computing and technology. That would be useful, because and I'll leave that to you, because I'm no expert on that. Kenneth said about restrictions of in terms of process engineering, mining, pipelines, etc. I know that they cross over in terms of other legislation that we have domestically, but internationally, I don't see that there should be any limitation to the applicability of adjudication as dispute resolution across any international projects. In fact, there are infrastructure projects, and I would class many process engineering and oil infrastructure, for instance, as being suitable for clearing the way for adjudication in that respect. And I think the other areas that domestically would be beneficial in terms of there's some accord in terms of domestic and residential disputes, which are at the moment excluded from the adjudication process, no statutory right to adjudication. I think that would be beneficial because the experience that the adjudication world has in regard to general construction can be easily applied to the residential. Internationally, I see huge benefits to application of adjudication, and for regions and jurisdictions which particularly suffer from, in my experience, from disputes being shunted into arbitration for convenience to tie up disputes for a significant amount of time. If we go back to the origins of adjudication and the importance of adjudication, it was about cash flow, it was about making a project move forward, and it was about ensuring that some form of resolution, early resolution, whether or not it be interim or final, could be achieved. It's something I think many international regions could benefit from significantly. And if the acceleration of infrastructure projects, particularly in my experience in East Africa, could have adjudication introduced, I think it would be extremely beneficial, where you have the ability to resolve disputes across supply chains, different jurisdictions, as infrastructure projects cut across geographic and political boundaries. So for me, adjudication, if it's driven by region, if it's driven by sector and driven by industry, would be beneficial in all forms. The key thing for me, though, is ensuring that if you're going to do it, if adjudication is there, then there are significant, in my opinion, and Sean and Kenneth will probably have much more robust views on it than I do, but if you can get the enforceability of adjudication across all regions, and you can introduce a statutory right to adjudication, I think that would be extremely beneficial. So,
thank you, Marcus. I think it's really interesting. I'm quite struck by some of the overlap between the points you've made there, and also the discussion that we had in the last webinar session on low value adjudication and the conditions that are necessary in order to make sure that adjudication is still fulfilling what we've spoken about as being its benefits, which is that it is accessible and cost effective.
I think that's particularly important internationally as well.
Yes.
Or we talked about, and I know Sean raised it, in terms of the issues of I call it weaponization. I probably shouldn't do, but I just think that if we can get access, cost-effective access to adjudication and to dispute resolution for the primary importance of moving cash flow, it will be a huge benefit. And perhaps in the application of adjudication, that recognition internationally of a low value adjudication equivalent, if that could be bound in so that there may be two subroutes, for instance, depending on complexity and depending on value, then I think that would be beneficial. But I think it's important that we don't confuse levels of complexity with levels of value, because they change. Yes. They change with the market that you actually operate in, and they also change in the relative size of the parties as well. So to you and I, a sub $100,000 dispute may be small, in inverted commas, but they're absolutely vital to the parties to resolve. And therefore, depending on the size of those parties, they can be sometimes much more important to those individuals as something 10 times the size.
Thank you, Marcus. I think that's an excellent point. The value of the dispute is not a proxy for complexity by any means. I'm going to open up a polling question for the audience in a moment on this question of the statutory underpinning for adjudication and whether that is a necessary condition. But just before I do, we've had a couple of questions come through on the chat, so thank you very much for this. In particular, Seth Handley has asked about whether, and this is directly relevant to the polling question, I believe, which other professions have the need for a right to adjudication as opposed to just a mechanism being available? Sean, did you want to address this point?
Yes. I thought that was a really interesting question, because it might appear, and I'm thinking on my feet now, why would you need quick decision making? Small companies are in the same position, whether they're in construction or any other industry. And if they have a dispute with, say, their accountant or their lawyer or any other professional that they have engaged, it could be extended into what I think of as perhaps more quasi-professionalisms like marketing or some kind of advisor. If you want to get a dispute sorted out quickly and you are a small company, then cash flow is still a problem for you. But I can see that there won't be the same volume as construction matters. That said, my experience from when I was a junior at the coalface in professional negligence is that there is a massive, truly massive volume of complaints, particularly against lawyers, which don't make it through any further because we now have the pre-action protocol in Great Britain, and that involves an exchange of letter of claim, letter of response, and so on, and a lot of matters get resolved at that stage. Some people who go beyond that would take their complaint further, but now they face a £10,000 issue fee, and that is certainly a barrier. So I think the combination of the changes to the court rules means that there is gone from a possibility of an adjudication route to really a need for something which is cheaper and quicker than going by the court.
Excellent. Thank you, Sian. Ken, was there anything you wanted to add to that point just before I open up this polling question, and we can get into a discussion on the need for statutory underpinning?
Yes, I was very impressed, not just by the question, but by what Sian and Marcus have had to say. And I sort of thought, well, you know, if I were now to break it down into elements, what you know, where would we be without a statutory scheme? Number one, people would have to be aware of the existence of a scheme, so it would have to exist. And number two, people would have to know about it and be able to trust the process. Number three, it would have to be enforceable. And that might mean, as Marcus has indicated, enforceable across borders in terms of certain industries and indeed across continents. And then that raises the question of, you know, would all this, if you had all those elements, if you had a workable scheme that people knew about and could trust, and it was enforceable even across borders, would people use it unless they had to? So that's the element of compulsion. Does it need to have a statutory underpinning or an element? I mean, effectively, construction adjudication is compulsory. Effectively. There's no two ways about it. You can't avoid it. Would one have to introduce that? Because I think that would be extremely difficult to achieve. It might be applied to one or more sections like construction, but thinking of it in total, in commercial terms, across all industry and commerce, you can't ever see it being compulsory. So it then relies on various bodies' encouragement, judicial encouragement, and as Sian has rightly said, the need for something that is different from high court litigation or arbitration.
Yeah, I would, Kenneth, it is a tricky one to apply to everything, because we deliberately broadened the application of adjudication. But internationally, there's much mischief to be had in terms of binding up a dispute, much mischief. And it's become commonplace. And it'd be interesting to see what our attendees think internationally. There's much mischief to be had to actually pop a dispute into arbitration, as we mentioned earlier, to bind it up for six months or 2 years. And I think sector application of a statutory right or industry would be beneficial, so that if you look at the potential for the AFCTA, African Trade Nations organization, to apply statutory adjudication, for instance, for commercial disputes across borders within the region, and key projects, for instance. So let's not forget building the team, and Latham, as Seth reminded me in the chat, was about ensuring that projects could proceed. And sometimes we underestimate the problems that having a live dispute within a project has, particularly on litigation, or particularly something significant, because it will effectively bind a project so that nothing happens on that project. And that was one of the key issues that Latham addressed, particularly for infrastructure projects. So the likes of infrastructure projects or critical projects or sovereign funded projects, for instance, might be an area where statutory adjudication may be beneficial. But applying it to everything, yeah, could be problematic.
Thanks, Marcus. I think this is a good time to bring the audience into that question. So we should have a live poll just coming up on your screens in a moment. This really relates to again this question about what makes adjudication effective. Does it need to have a statutory basis? So that is now up. If the audience members would like to vote, just be interesting to see what your views are on that. We'll just give a moment or two to cast that vote, and then we can get into. I think we can perhaps digest what the audience's views are on that, and also talk about some of the other obstacles and barriers that there might be to take up in different fields. And I think each of you have made allusion to the point that will vary across industries and across professions. It's very dependent on the particular circumstances involved. It might be good just to get into some of the detail and unpack that a little bit. So we just give a. Sorry, Sian.
There's one question that's well, there's a few questions that have been put forward by the audience, and one is from Pnba, and then I can't see the rest of your name, but it's saying about, can adjudication be used more widely? I think it's the best mechanism to resolve disputes, and I would like to train and use this mechanism. And I was just thinking, in answering that question, how could that be done for professional negligence dispute? Because one of the panel rules is that you need to be a Queen's Counsel or senior junior with a certain level of experience, which is determined by the panel selection. So in order to move that from being a relatively confined scheme to the United Kingdom, and of course, United Kingdom lawyers are split between England and Wales as one jurisdiction, Scotland as a separate one, and Northern Ireland as a separate one again, with Ireland having its own jurisdiction. So it's a small area, but it's clearly adaptable. Any country that has professional negligence specialist organisations could set up their own scheme, and there is now a model that can be followed. And we have, under the aegis of the Chartered Institute, the perfect route for having some cross-fertilization between all those different countries and the different specialist bar associations. And it strikes me that now is the time. There is a need for this, and it's worked in construction. It's doubtful that a statutory scheme will come into force for professional negligence, certainly in the United Kingdom, but there can be a commercial route to achieving that, which is that people vote with their feet. So within the retainer, that there be a dispute resolution provision, which includes and allows for adjudication as an option, and then promulgation of a scheme so that people get to know it. And the best way for people to get to know it is for it to be advertised by an already well-known existing international organization that can say, well, and here's another one to add to your string, as this participant said, I would like to train and use this mechanism. Well, people who are interested in arbitration are the perfect group of people to train to become adjudicators in professional negligence.
Excellent, thank you, Sian. I think it is a really good point, and I think there have been a number of questions or comments from audience members which are in that vein as well. I think it does touch upon an interesting question for me, and I might be interested to hear the panel's views on this, which is that and just to say, our polling question results are in. it's by 82% to 18%. The audience, or those who answered the question, believe that adjudication does need a statutory basis in order to be effective. So I think that's really quite interesting. But just get back to your point, Sean. When construction adjudication was introduced in the UK 25 years ago, obviously part of the intention is that people with a background in construction itself, who may have encountered those similar problems that arise, will make good adjudicators, because they can perhaps understand some of the complexities and some of the nuances about disputes that arise. And I just wonder what the panel's views are on the balance between perhaps legal expertise and sector-specific expertise in delivering an adjudicative process.
For my part, I've just realised I've left my speaker on all this time. My apologies if you've been hearing background noise. From my perspective, it strikes me that, you know, it's horses for courses. If you have a complex accountancy dispute, then a lawyer is at best looking at it via the eyes of the expert evidence that they've got. It cries out for having an accountant as the person who is dealing with this. And so, you know, it spreads outside just lawyers. That's the obvious example I can think of. But, you know, another huge field is financial advice. And there is an extraordinarily complex set of rules, which is constantly evolving. And that's just within England and Wales. Every country, no doubt, has its own body of financial advisors, and the training and the qualifications and what's expected of them will be so hugely variable that I can't really see that lending itself to lawyers considering it. Although in this country, under the Pnba scheme, that would be lawyers looking at it, but it would be people who have a lot of experience of looking at that. And of course, legal textbooks are written by lawyers who work in these areas. And so you'd have that kind of academic come practitioner working in a specialist field of law, which is also a specialist profession. I don't see why that can't be replicated for every country that wishes to do this.
Thank you, Sean. Marcus and Ken, did you have anything to add to those? There's been a couple of questions which relate to that point, and whether sector-specific expertise is necessary.
I mean, I favour sector-specific because, as Sean has said, untangling a Gordian knot where you're unfamiliar with the terminology. And I think we've got to get away from the people saying that they are, because they are familiar with the terms, that they understand the complexities of the particular sector that they're dealing with. So my main sector is construction and consultancy and everything around it. But it would be difficult to move into a technology sector, particularly with adjudication, where your unfamiliarity with the terminology or the dynamics of the arguments that you are seeking to adjudicate upon, if you then have to inure yourself in the background of that particular sector, as well as dealing with the key issues that you're there to deal with, if you like, the balance of decisions against or with the parties, it becomes unwieldy. So sector specific, discipline specific, even where construction is concerned, I think is beneficial. But I don't know, Kenneth, whether or not you're of the similar sort of vein, but yeah.
Thanks, Marcus. Ken, did you have anything to add to that?
Yes. I can't disagree with anything that's been said by Sean or Marcus. Experience tends to show that parties don't agree on the adjudicator unless that adjudicator is named in the contract, certainly in construction. So it means that the referring party is going to apply to one of the adjudicator nominating bodies. And they will probably choose the one that they think is going to give them the best result, or is more likely to produce the result they desire. So they might choose a quantity surveyor, and that might be the right choice if it's really about valuation, or they might choose an architect. But my experience has been that, for example, the RICS, the Royal Institution of Chartered Engineers, has probably one of the largest and most diverse panels, and lots of people go there as a matter of course, or will select that body as the adjudicator nominating body when they sign the contract. So there's an element of choosing the tribunal that you think is more likely to be sympathetic. All that said, if it's a dispute that crosses, let's say legal, factual, as well as technical issues, one might prefer a lawyer rather than someone who's not a lawyer. And then there are those adjudicators who are dual qualified, who might be both barristers and quantity surveyors or whatever. So, there's the panels are now so extensive, and there's such a fairly large choice that, you apply to the panel, you state the nature of the dispute, and you might even state your preference as to the kind of adjudicator you want. But it is, after all, horses for courses. And let's remember, it's the referring party who gets basically to choose, although panels don't always give you what you want. I don't think I can say more than that.
Thank you, Ken. I think that it's a good point. It's certainly been our experience at CIArb as an adjudicator nominating body, which is that when the referral comes through, the background information will often be very, very extensive and often very niche. And so the need to have quite a broad and wide-ranging panel, but with depth of experience, often in really quite specialist areas, is quite important. I have found that to be the case, and I think that would be true outside of construction as well. Although I think Sean did make a good point that it's very much dependent on the nature of the dispute in question. I just want to address, because I'm conscious that we're nearing the end of the discussion, and I think we've been able to address quite a lot of the questions that have come through. But there were a couple of questions. So from Obi, we've got a question on what exactly is the difference between adjudication and arbitration, and how does that differ from litigation? I know that we covered that, and certainly Ken in your introduction, and many of those joining would. But if you were able, Sean, perhaps just to give a thumbnail sketch of that.
Yeah, I mean, it's more the indicative signs of, because you're absolutely right. These are all dispute resolution mechanisms, so they have certain similarities. They have warring parties who end up with a decision. The adjudication route is consensual, contractual. It doesn't have a statutory backing except in construction adjudication, and it's effectively a scheme that is designed to make it a short turnaround. So for both arbitration and litigation, when you commence it, you don't know when it will end. And because you don't know when it will end, it means you don't know when you'll get your answer. And you also don't know how much you're likely to be shelling out to do it. Adjudication is an attempt to move away from that so that you have a defined end point, 56 days after appointment of the adjudicator for Pnba, 28 days for the original scheme under construction adjudication. And that's the effectively the USP, the unique selling point of adjudication is speed of final determination. The rest really is a secondary effect. Because the litigation period is so much shorter, one assumes the level of costs will go down. And largely that is the case because it's actually hard to expend the level of costs in around a month and a half to what you would expend in the usually approximately 2 years it takes to get to a conclusion in arbitration. Unfortunately, the use of lawyers in adjudication, which started out as a scheme, I think Kenneth has described it in this way, designed to enable payments to come to the smaller subcontractors that needed them so that they weren't bogged down and risk going insolvent in the time it took to get payment from contractors. A scheme that was designed to assist that scenario has grown and grown and been applied elsewhere. And I've certainly encountered final account disputes going via adjudication, which clearly and obviously to both sides and the adjudicator were not suitable to adjudication. But nevertheless, somebody had started it, nobody was going to back down, and so you carry on. And so the scheme ends up becoming an extended timetable because parties have to agree more time because it's simply impossible to get through the volume. And so adjudication, the highlights of it are the speed and the reduced cost. And I suppose the oddity is that it's a binding decision, but until somebody takes it to a court or a tribunal to challenge. So in essence, that person who would take the challenge is the losing party, and the winning party would be seeking to enforce the award. The losing party would be seeking to get a different decision when they go to court. And I suppose that's the other distinguishing feature of adjudication, whereas of course court and arbitration, you're already there, you're already on the route to getting that final and binding determination.
Excellent, thank you, Sean. I think that was an excellent encapsulation of the differences. I'm conscious.
I was going to say there's a couple of questions that I just quite quickly wanted to address.
Yeah, certainly.
In the question line, where's the one? It's one about the use of evidence. Certainly in my experience that the evidence from the adjudication can be used in subsequent court proceedings. Indeed, the decisions are often in there as part of the ongoing future dispute. And sometimes what's happened is that the adjudicator has come to a series of decisions. They've all been enforced, they've all been paid, but the party that is aggrieved by them will then take court proceedings in order to demonstrate that that is not the outcome that there should have been and that there will need to be repayment back of monies paid across. It's not the commonplace setup that happens, but it certainly does arise in that case. And the expert evidence and so on, it effectively becomes factual evidence in the subsequent proceedings. So you'll have a new level of experts dealing with looking at that evidence. Are the experts compensated and by which party? That's by the party. The costs incurred by the party may well be recoverable in the adjudication, and that is decided by the adjudicator, who is in fact told what kind of cost orders they can make based on the agreement between the parties at the start. So if the parties agree that costs will follow the event, the winner will get the costs. If the parties agree that the parties will bear their own costs, that's what the outcome will be, and the experts' fees will be treated in the same way.
Excellent, thank you, Sean. And there was just before we move to the summary and some closing comments, there were just a couple of other questions. Firstly, thank you to everyone in the audience for keeping these coming. I do apologise if we don't get time to come around to yours, but I'll try and cover as many as we can. There's a question around what happens if the adjudicator is unable to give their decision inside the given timeline, whether it was under the particular scheme as you've described, Sean, or under statutory construction adjudication. Is the decision then enforceable? And I wonder, Ken, if you wanted to address that point.
Absolutely. In terms of the construction, the scheme for construction contracts, the judges have decided fairly early on that if the adjudicator didn't give the decision within the time that within the time that the scheme permitted, or within any extended time that the parties agreed, the decision would be void and unenforceable. There were a couple of interesting cases where the adjudicator missed the boat by a couple of minutes after midnight, and that led to some some great soul searching, because the courts really wanted to enforce the decision if they possibly could, and found ways around the time limit if it was only a matter of a very short time overrun, especially where parties had submitted or made further submissions, as it were, just before the deadline. So basically, if you're out of time with the decision, then it's unenforceable. That depended entirely on the rules under the Construction Act, and I suppose you could have a set of rules which provide for that contingency, but that would lead to so much uncertainty. I suggest that any set of rules that has a time limit, they're going to run into the same problem. If you're not in time, it's likely to be unenforceable.
Thank you, Ken. That's very illuminating, I'm sure. So I'm conscious that we've only got a few minutes left. I think this has been a fascinating discussion, certainly from my point of view, and I trust that our audience has found it to be as well, judging from the engagement in the chat function and the questions that have been coming in. I think that's certainly true. I just want to give everyone a chance for some final words. So if we start with you, Marcus, if you were to just leave the audience with one thought from today's session, what would that be?
In your own sector, in your own experience, if you feel that adjudication has benefits, then you should gather together and see what can be done in your own jurisdiction to promote adjudication, if you believe it is beneficial, because the movement has to come within, I believe, if you want to affect the change and to get the discussion going, to ensure that your own jurisdiction is going to recognise adjudication. In my own regions, South Africa are very pro-adjudication and allow adjudication to be enforced. In Tanzania, for instance, the opposite is true, and it's problematic. But I think the change has got to come within, and to raise the issues and raise the questions as widely as possible.
Excellent, thanks, Marcus. And Sian?
Yes, I think we are perhaps at the start of a new chapter in adjudication. Construction adjudication was the opening chapter. It was a big chapter, and it's spawned several others. And now perhaps we're ready for the next.
Thank you, Sian. I think that's a really good point. And I think, as you said, bodies like CIArb, given our international reach and the breadth of dispute mechanisms that we cover and our professionals cover, puts us in a unique position to do that. Ken, the final word?
Possibly then a word of encouragement. Some years ago, I was negotiating a commercial contract, and it wasn't a construction contract, although it had certain parts of it which might have looked a bit like construction. It wasn't. It was not only not caught by the Act, it wasn't a construction contract in the real sense, because it involved the supply and fitting of goods on trains, effectively kitchens for the West Coast Main Line. It took 18 months to negotiate the contract, during the course of which I suggested that we adopt an adjudication scheme. At that time, the Texas scheme was what seemed, with some modifications, seemed suitable. So the other side eventually agreed, and it went in the main contract and the subcontract. And the rider to all that was that there was a dispute that developed 2 weeks after the contract was signed. 18 months to negotiate, and a dispute within 2 weeks, as I have to say was predicted. The existence of the adjudication clause meant that we were able to persuade the other side, or at least they offered to mediate, and it was resolved within a week. So, you know, and that was an ongoing relationship that needed to be kept. So, you know, there's no reason why you can't think about it when you sign your contract, even if it isn't there. Think about, there are schemes out there you can adopt.
Excellent. Thank you, Ken. And I think that's a really strong and encouraging note to finish on. Thank you again to all of our audience members for joining today, and thank you once again to our panelists. That's been an excellent discussion. If you are interested in knowing more about adjudication, if you go to the web page that's provided at the bottom of this slide, you can watch recordings of previous adjudication webinars, and indeed this one will be made available online in the next few days. You can read articles from leading authors in the sector on everything from how adjudication has evolved in construction in the last 25 years to how to establish a brand and a presence as an adjudicator, from the likes of Matt Malloy and Tom Hawkins. And you can refer to our own construction adjudication clause. As we've referred to, the Chartered Institute of Arbitrators is an adjudicator nominating body, and we've got a very experienced and a wide-ranging panel. We've also got some adjudication courses upcoming. So if you're interested in that, visit our training page, and you can see about how you can access those courses online. And then finally, we have a number of events coming up. So in a couple of weeks' time, we've got the Mediation Symposium, which you can still book for, the Alexander Lecture in November, and the Dispute Appointment Service, which will be on the 1st of December, and the booking will open shortly for that. And adjudication will form part of the programme. So if you're interested in hearing about that and a range of other subjects, please do register. Thank you once again. It's been a pleasure speaking to you all, and thank you again to our panelists. Thank you.